Void marriage. In the Philippines, marriage is a special contract of permanent union between a man and a woman, entered into in accordance with the law for the establishment of conjugal and family life. It is regarded as the foundation of the family and an inviolable social institution, meaning it cannot be easily dissolved. Its nature, consequences, and incidents are governed strictly by law, and private agreements cannot override legal provisions, except in determining property relations through marriage settlements, which must comply with the family code. To ensure that marriages are valid and legally binding, the family code of the Philippines provides for essential and formal requisites that must be complied with. The essential requisites, as outlined in Article 2, include legal capacity and consent. The legal capacity requirement means that both parties must be of legal age and must be a biologically male and female. As same-sex marriage is not recognized under Philippine law, consent must also be freely given without force, intimidation, or fraud, and must be expressed in the presence of an authorized solemnizing officer. Meanwhile, formal requisites of marriage listed in Article 3 include the authority of the solemnizing officer, a valid marriage license, and a marriage ceremony. The law specifies who may solemnize marriages, including judges, priests, imams, ship captains for deathbed marriages at sea, military commanders in war zones, and consuls for Filipino marriages abroad. In general, a marriage license is required before the wedding, although exceptions exist, such as when the parties have cohabited for at least 5 years without any legal impediment, or when the marriage is conducted under Muslim or indigenous customs. A valid marriage ceremony must take place, where the couple personally appears before the solemnizing officer and publicly declares their intent to marry, witnessed by at least 2 persons of legal age. The absence of any essential or formal requisite renders a marriage void from the beginning, void ab initio, meaning it has no legal effect. However, if there is a defect in any requisite, the marriage remains valid, but the party responsible for the irregularity may face legal consequences, civil, criminal, or administrative. Void marriages are listed under Article 35, 36, 37, and 38 of the Family Code. 1. Lack of essential or formal requisites. Family Code, Article 35. Formal validity refers to procedural requirements for a valid marriage, while essential validity refers to fundamental requirements for a valid marriage. The essential requisites, Article 2 Family Code, are 1. Legal capacity of the contracting parties, who must be a male and a female, and 2. Consent freely given in the presence of the solemnizing officer. The formal requisites of marriage, Article 3 Family Code, are 1. Authority of the solemnizing officer. 2. Valid marriage license. 3. A marriage ceremony which takes place with the appearance of the contracting parties before the solemnizing officer and their personal declaration that they take each other as husband and wife in the presence of not less than 2 witnesses of legal age. 2. Lack of age capacity. Marriage involving minors is now categorically void, regardless of parental consent. Penalties are imposed not only on the participants in the marriage, but also on adults who facilitated or coerced the marriage of minors. 3. Bigamy or polygamy. Bigamy refers to marrying someone else while simultaneously being married to a spouse who is still living. Polygamy refers to the practice of having more than one spouse, especially a wife, at once. 4. Marriages without a valid license or proper solemnization. 5. Psychological incapacity. 6. Incestuous marriages. Marriages between the following are incestuous and void from the beginning, whether the relationship between the parties is legitimate or illegitimate. A. Between ascendants and descendants of any degree. Descendants are the children and grandchildren, while ascendants are parents or grandparents. B. Between brothers and sisters, whether of the full or half blood. 2 siblings who have the same mother and father are considered full-blood relatives, while half-bloods are siblings who share only one parent. 7. Marriages within prohibited degrees of consanguinity or affinity. Marriages between the following shall also be considered void. A. Between stepfathers and stepdaughters, and stepmothers and stepsons. B. Between the adopting father or mother and the adopted, between the latter and the surviving spouse of the former, and between the former and the surviving spouse of the latter. C. Between the legitimate children of the adopter and the adopted. D. Between those who have been condemned as authors or as the author and accomplice of the death of the spouse of either of them. Voidable marriage. In Philippine law under the family code, marriages that are voidable, as opposed to void ab initio or valid marriages, are those that remain valid and binding until annulled or set aside by a court of law. Voidable marriages exist despite certain defects or issues at the time of marriage, but these defects provide grounds for annulment if actioned upon by a party. Under Title I, Chapter 4, Articles 45 and 46 of the Family Code, voidable marriages are defined, and the specific grounds under which a marriage may be annulled are detailed. The process for annulment on these grounds generally requires a judicial proceeding, and the action must be brought within a specific time frame or under particular circumstances, depending on the grounds. The Family Code specifies 6 grounds under which a marriage is considered voidable and may be annulled. Lack of parental consent. Article 45, Paragraph 1. If either party was 18 years of age, or over, but below 21 years of age at the time of marriage and did not obtain parental consent, the marriage may be annulled. The action to annul must be filed within 5 years after reaching the age of 21 by the party whose consent was not obtained, or by a parent or guardian. 2. Insanity. Article 45, Paragraph 2. If either party was insane or mentally incapacitated at the time of marriage, the marriage may be annulled. This action can be filed by the sane spouse, the relative or guardian of the insane spouse, or the insane spouse once they have regained sanity. The action must be filed before the death of either party. 3. Fraud. Article 45, Paragraph 3. The marriage is voidable if consent to the marriage was obtained through fraud. Types of fraud. Recognized. 1. Non-disclosure of a prior conviction for a crime involving moral turpitude. 2. Concealment of pregnancy by another man. 3. Concealment of a sexually transmissible disease that is serious and appears to be incurable. 4. Concealment of drug addiction, habitual alcoholism, homosexuality, or lesbianism. An action based on fraud must be filed within 5 years from the discovery of the fraud. 4. Force, intimidation, or undue influence. Article 45, Paragraph 4. A marriage is voidable if consent was obtained through force, intimidation, or undue influence. The action to annul on this ground must be filed within 5 years from the cessation of such force, intimidation, or undue influence. 5. Impotency, Article 45, Paragraph 5. The marriage may be annulled if either party was physically incapable of consummating the marriage with the other, and such incapacity appears to be incurable. This action must be filed within 5 years after the marriage. 6. Sexually transmissible disease, Article 45, Paragraph 6. If either party was afflicted with a sexually transmissible disease that is serious and appears to be incurable, the marriage may be annulled. This action must be filed within 5 years after the marriage.